president of the Connecticut, Western Massachusetts chapter of SIOR. So our guest this week is David Glissman, real estate attorney extraordinaire and partner of McDermott, Reynolds and Glissman. Dave is a chapter annual sponsor and has been a colleague for a number of years. And he also, several years ago, he assisted with the chapter's initiative to be legally compliant by helping us to update our bylaws, being properly registered with the Secretary of State, and other related items as encouraged by SIOR Global. And we continue to thank Dave for all of that. So before we begin, I just wanted to acknowledge all our annual sponsors who are listed at the bottom of our invites. So we have Bank of America, Community Investment Corporation, Claris Construction, Declare Office Group, Godfrey Hoffman, Hodge, Land Surveyors and Civil Engineers, Dave's firm, MR&G, RD Cinto, Petra Construction, 10X, Savings Bank of Danbury, and PES Structural Engineers. So the format, it's going to be like we've been doing the last few weeks. Everybody's going to stay muted, and individual videos will be disabled as well. And we have the chat function is enabled. So if you have questions, please use the chat function, and we will mix your questions in with the discussion. And then again, if everybody can just remain muted, that would be great, so we can all hear Dave. He has a lot to say, interesting things. And lastly, we're going to be recording this session like we have the others, and it will be up and available on our website. So let's have fun and let's get started. So Dave, most of the folks know you, but not everybody does. Hard to believe. But why don't you give us some background on you and your firm?
All right. Well, listen, everybody, first of all, thank you very much for joining us this afternoon. This is a neat opportunity for me to present to you. And Art, thank you very much for giving me this opportunity. Thanks. And good afternoon, everybody. See your names popping up. I think I know most of you. You've done deals with me, I with you over the years, seen you at all kinds of things. But I don't know that you guys necessarily know anything about my firm. So McDermott, Reynolds and Glissman was founded in 1992. We have 11 attorneys, and we're like your classic old school, old fashioned commercial real estate law firm. That's pretty much all we do. About 95% of our practice is commercial real estate. We've got 11 attorneys, 2 of whom are litigators. The rest of us are sort of transactional guys. We've got an office here in Connecticut. We've got an office down in Raleigh, North Carolina. Man, Raleigh is just popping. What a place. We have a kind of a soft relationship with a firm in Massachusetts, Prince Lobel, where we do a tremendous amount of cannabis work. And we're sort of moving a little bit into Connecticut, kind of a hemp market seems to be picking up a little bit here. So we have transactions all up and down the East Coast. We're doing stuff in Florida. Right now, on my plate, we have stuff in Florida, Virginia, New York, Pennsylvania, Texas, Massachusetts, Connecticut. And so, and our deal size is kind of all over the place. You know, we've got $100 million portfolio sales, high-end financing, Wall Street money that's complex and fun to work on. We've got $100,000 office condominiums, and we have everything in between. We've got a fair amount of Transfer Act work, which is of interest to you. I think I have 2 going right now, coincidentally, both with Pam Elko, somebody that you're all familiar with, whom I like quite a bit. And we also have something that is of interest to the brokerage community, and we've worked with some of you. We have a brokerage group in our firm where we do listing agreements, really mostly listing agreements, and not even that many of those, and a fair amount of broker liens and that kind of thing. Our litigators are doing, landlord tenant work, foreclosure work, and we really just have this neat law firm, small law firm with a really sharp group of people, a lot of senior, super seasoned people, and some newbies that love doing real estate, a great group. So Art, thanks very much for letting me say who MRG is, a great group.
So does that kind of sum up your activities and your scope of work pre-COVID, Dave, or is there anything else you want to add?
Well, I'd say a couple things. So first thing I would say on pre-COVID was we really were kind of rocking and rolling. It was really busy, doing a lot of buy, sell, lease, financing stuff. Most of them were kind of moving towards closings, and then and then the big bomb drop, whatever that was, March 10th, March 12th, and so it was really very interesting because I, of course, because we were so busy, was just at the tail end of hiring 2 new lawyers. I hope I'm not like a complete moron for having done that, but these guys were just incredible. They're incredible guys. So I said, okay, we're doing this. So I went ahead and sealed the deal with both guys. They're both here now, great guys, happy with that decision. But that was then, and kind of a lot happened, when the bomb exploded.
And the two attorneys are staying put for now.
They are staying put, period.
That's great. So how about now?
Well, so yeah, it was very interesting, kind of what happened. So when the bomb hit, work just stopped. I mean, everything just came to a screeching halt. Not a single phone call came in. I thought, oh man, this is not a very good situation. And in fact, there was a survey that was done of law firms, of real estate lawyers from this real estate blog that I'm party to, and 58% of the real estate attorneys polled said things had really come to a serious halt for all of them. And I know from this blog, law firms all around the country still today, there's more on it today, are cutting back, letting attorneys go, cutting back partner salaries and draws, cutting back on staff. So there really was this stop to the business. And I think, one of the things that is always indicative to me of this, because I did it and you guys got them, and I don't mind saying so, they were pretty freaking awesome newsletters that I sent you. But you can tell.
I would agree. I would agree. Since no one else can talk, I'm gonna cheer.
You can tell when business is slow when you're just flooded with newsletters from lawyers, and we all are right now. Some of them are great. I read them. So anyway, things were really, really slow, and so the kinds of stuff that we were doing, all of a sudden, and I think some of this is relevant now. It's relevant to what's going to be happening right now. What we were doing was there was this emergency, like PPP thing. Everybody was trying to get their apps, and we were just living that, trying to understand it, tell people how to do it, and some of the other programs. So we were doing a fair amount of that, and that started getting us busy. And then, and then there were the lease and loan mods. And I think it would be interesting for you to know, because I don't think we're done with this. I think this is coming back probably, and you guys are going to all be on the front lines again, negotiating just as you did last time around. So if we take like retail, one of the things that we saw in retail was, everybody came out of the woodwork almost immediately in April. And most of our landlord clients were doing 3 to 6 month deferrals, some with partial forgiveness, and a lot of them were asking, that it be paid back as soon as the deferral period was over some period of time, 6 months, a year, something like that, usually without interest. What is interesting, and I think this is relevant very much for today, is that, I've been reading that the retail tenants are saying, the world is changing. People are having their food delivered to their home. People are having all of their goods delivered to their home. Brick and mortar retail is a question mark. I know you know that. I'm not telling you anything you don't know. But the question is, what does that mean for the rent structures that all of these guys? And Tom, you just emailed us a few minutes ago with a question, and that was, what are tenants asking for? And a lot of retailers. Tom, yours was an office lease. But what retailers are now saying, and I've got my first one. It just came in. I was working on it yesterday, as a matter of fact. And that is, retail tenants are saying, look, I don't know where this is going, but I'm not going to pay you what I was paying you. I want to talk to you about something different. I want to talk to you about, percentage rents, sharing of profits, something. I'm willing to talk to you, but I do not want to lock into these fixed rate numbers. And I've been reading about it. I hadn't seen it. And all of a sudden now I've got, I got my first one in. I was working on it yesterday. And landlords, I think, are going to be talking to the tenants. Part of it was going to be, does the tenant have renewals coming up? Do they have any leverage? Is there a reason to have this conversation? But if you want to keep the tenants, you don't want a big new TI allowance that you got to dish up and put somebody else in there. You're talking to them. So what we're talking about now to our clients on this is we're saying, okay, if you're going to have that conversation, we get it. Maybe you ought to be talking about what happens if they start doing well again. Do they have to go back to the old rents that they were paying? What happens if they suck and they're just dying on the vine and you're getting nothing? There ought to be a termination right in there. So we're trying to put some collars now on this conversation, and I think you guys are going to be having those conversations on, sort of on office and medical. It was mostly just kick the can down the road stuff. And it's interesting, Tom, that you have an office client now that's saying that they want to do something different, that they don't want to pay the rent that they're paying. I'm going to talk about that in a little bit, but I think it's a function of now of leverage. Do you want to keep these tenants? Industrial clients, the ones that had distribution centers and things like that, the big boys seem to do okay. They kind of rode out the storm. The mom and pops, the smaller companies, the ones that are, feeding the stuff that was dead, they were all in trouble. And most of our clients gave extensions, 3 to 6 months deferral, and then you got to pay it back over time, and then there were loans. Apartments. Apartments, everybody was afraid was the end of the world, and it ended up, it wasn't. Everybody was kind of paying. The rents weren't all that bad in April and May, and people are kind of crossing their fingers right now to see what's going to happen to June. To July, April, May, and June. I'm sorry, to June. But when they went to talk to lenders, as they were getting shaken down by their tenants, we got involved with these lender conversations, and it was kind of the same thing. What we found was most of the local regionals, most of the banks, in other words, were kicking the can down the road. They agreed to do something, to help you, 3 months, 6 months, something like that. Fannie was good. Freddie and HUD and CMBS, much more difficult to work with. I don't really know, whether they're going to get any easier here down the road if we have another round of this. But swaps were kind of a problem, and swaps will be a problem again, because if the swap is held with the original lending bank, some of which are, they kind of just use the mechanism, but do the 2 parts to a swap deal, the basic loan and then a swap. They were working with the tenants, with the borrowers, and doing a kind of classic deal. But some of the banks, the swap partner is a third party, and those are fixed contracts with their rates established in them, and you kind of can't break them, and you kind of not supposed to stop paying on them. So one of the clever things that one of the lenders did, which we saw, and it's good for you to know as just a tool if you have to deal with it, is the lender advanced the borrower a credit line to pay the mortgage for 6 months. That allowed, so now the bank is really funding the swap payments, but it's kind of like a forbearance. So I thought that was kind of a cool thing. So we saw a lot of that. But now, I think this is the last part of this, kind of piece, and that is that I don't think anyone really believes that this is 100% over. And I think we're all kind of thinking that we're going to be having this conversation again. And guess what? All of those 3-month deferrals that everybody gave are just about up, April, May, and June. And I think starting the first, second week of June, all of our landlords are going to be approached. And now they may be approached with something more substantive, Tom, like what your clients are asking for, or like what, what mine is asking for. And I think the only difference this time, I think lenders want to kick the can down the road. I think landlords are likely going to try to work with their tenants if they have to. I think the difference is, and you can just hear it in the voices of the people that I'm talking to, I think the landlords and the lenders are both saying, lenders as to the borrowers, landlords as to the tenants, do I think that this guy is going to survive another round of this? And if my gut instinct is no, maybe I'm going to cut my losses now and not accommodate this tenant. First time around, it was knee jerk. Oh my God. Okay, fine. You can have 3 months. Let's hope this goes away. But I do think, and I think the lenders are going to say the same thing. Are they comfortable with where this is going? So I feel like we went from the super busy to like dead in the water. And then there was kind of all this sort of workout stuff that kind of worked its way out. And then that kind of brings us up, to where we are now.
So you really, the last couple of 2.5 months, it really has been a lot of workout type work.
Right.
Any other sort of client stories or optimistic stories that work that some of your clients, that any of your clients are involved in right now?
Yeah. Well, as a matter of fact, excuse me for just 1 second. Murphy's Law.
All right.
So the good news is the following. So kind of the neat thing about this was sort of while all this was going on, I was trying to figure out, what's happening, with the practice, etc. I learned, in talking to you guys, you are kind of like the hot shot, the big dogs, the SIORs, and you were all pretty busy, which was great news. I was thrilled to hear that because the commercial real estate lawyers, kind of run around in your dust. And when you are kind of done, our world kicks in. We start putting, the pieces together that you've kind of lined up. And so I was glad to hear that, but I wasn't seeing anything. And I thought, well, okay, it's going to come. So the good news, and I feel like I'm sort of a bellwether of the real estate lawyers market, because it's sort of like we kind of get our little piece, if you will, of the world, whether it's good or bad. And so I feel like if something's happening with me, it's usually happening in the market. And within the last several days, all of a sudden, the market has started heating up. Business has started coming in the door. I've opened several files, although they're kind of interesting. I'll tell you, Art, what, a little bit that I think is relevant. It might be relevant to what's happening in the market. So, so like I've worked on this morning, I'm going to have a long negotiation tomorrow on a purchase and sale agreement for a shopping center in New York. And the economics of that is that it's going to probably turn on the assumption of existing paper. I mean, you do that in New York to avoid taxes, but this is like real assumption of debt kind of deal to make it all work. I have 3 distribution centers that are just going to contract. I'm working on those contracts tomorrow and the next day, maybe this weekend, for down in Virginia, and they're pretty good sized deals. They're all multi-million-dollar.
Is that an investor purchaser or a user purchaser?
Investor. My clients are mostly investors.
Yeah.
And on those deals, those are deep pocket cash. So these guys are going to buy them, do what they need to do to kind of get them ready, and then at some point they'll put financing on them. So that's deep pocketed investor cash. It's not bottom fishing. I think they're paying market. These are properties that make sense for these guys. I just had come in. I'm in the thick of the negotiations on it right now. The purchase of a super expensive piece of land outside of Boston, where a client's going to put a big apartment complex on, all cash purchase price. Now I do have two financings that I think are just about to be approved and just about to come down the pike, which are one is a conversion to perm for now a fully occupied but brand new apartment complex. The next one is for new construction for an apartment complex, but with somebody that's got a real record. I will say that cannabis, if you guys can find your way into it, Art, I know you've done some. I think Mark Duclos, I feel like you were telling me that you've gotten some. I'm referring actually to the business side of cannabis, Art and Mark. And there are, properties, there's a tremendous amount of cannabis business up in Massachusetts, and there's now Connecticut people that are, interested in trying to get into it. We're starting to do some hemp here in Connecticut. So we have some of that kind of stuff going on. Those are, to me, pretty exciting things that are happening in the market, because it happened like in the last several days. Business is just starting to pick up, and boy, does it feel good.
Glad to hear. I think a lot of the brokers, particularly industrial brokers, are busy, and I'm extremely busy. We'll see where it all goes. All right, so most of the people online are deal people, and certainly all the brokers are. Dave, I know everybody's interested in lease documents and changes that you're seeing with lease documents, particularly things like business interruption, force majeure, which has become, no one knew what it meant before, and now everybody is trying to understand it. Could you address those?
Sure. So, it's interesting. Our viewing of leases in the last 2 months has either been as advocates to say you don't have to pay any rent, or as defenders saying, what the heck are you thinking that you don't have to pay any rent? Of course you have to pay rent. And so as we have looked at leases and thought about, advocacy and defense, we have also been thinking about, well, times are changing. Maybe what do we need to do to fix leases on a going forward basis? And it's a little different, I think, by class, but I want to touch on some of the provisions in leases, because I think your clients are talking to you and saying, look, I got a tenant saying they're not going to pay rent, or I don't want to pay rent. I know they're talking to you about this, and for you to have a few tools in your toolkit might be helpful. So one of the things that's kind of a hot item right now is common areas. This is more true for retail than industrial, but some of you get involved and touch on retail. In the common areas, the issues that we're kind of talking about now are pickup and delivery, outside sales, outside dining. And in retail centers, the big boy tenants, they have leases that say, you can't even think about walking across the parking lot, much less setting up a table without our permission. So common areas and the ability to use them to save these businesses right now, and then in the future, in case they need to do it, is all of a sudden becoming an issue. Plus, we now know, that pickup is becoming an item. So a lot of tenants are coming to landlords right now. We're doing them. We were doing them last week, saying they want to modify their leases to increase the definition of premises to include outside pickup areas. Co-tenancy rights in retail is another item that people are looking at as they're fighting, and also in the future. So co-tenancy is this provisional lease that says, look, if the big boys over there go out of business or shut down, I can get out of my lease, or I can stop my rent. It's a co-tenancy right that gives them rights. Well, guess what? There's a lot of shut down businesses right now. So everybody's kind of looking at the co-tenancy clauses. And interestingly enough, and I'm going to talk about it in a minute, I think, if you ask me again, Martin, force majeure. But there's force majeure and its effect, for example, on co-tenancy. Is the landlord really in default if the other tenants have shut down? And does maybe force majeure help the landlord in that situation, because he kind of can't stop it. It's out of his control. Co-tenancy is something that everybody's interested in. Janitorial services. I almost never worked on janitorial services. Well, I spent yesterday morning on janitorial specs because now everybody's talking about enhanced cleaning, bombing the offices, maybe monthly. And I had one client saying to me, Dave, it cost me $1,500 to bomb an office. And I can't do that. Some of my op expenses are capped. I don't think I can do this. So we're looking at that. I think they need to do it. They think they need to do it in order to win over new tenants in these properties because everybody's nervous to keep tenants, to get them to come back. So now we're looking at maybe provisions that say once the pandemic is over, you don't have to do it. And maybe the tenants have to pay for it before you're going to agree to do it. So janitorial specs, HVAC systems. When's the last time you spent any time talking about the filters that are going to go in them and the frequency of change and cleaning of the filters? I think most of us, when we're drafting leases, say, you're going to have a maintenance contract and move on to the next section. So now we're talking.
So Dave, so you have landlords that are afraid, or that they may have tight leases where there are caps on the expenses, where they're afraid that they're not going to be able to pass those expenses through. Is that
correct?
Yeah.
Right. And guess what? Gross office leases that include janitorial, you're right there. And there's plenty of Class B buildings. There's tons of gross leases out there in the office world. I think now we're kind of moving into kind of funky stuff that might be of modest interest, but there's a lot of looking at casualty and condemnation clauses, and it kind of relates, believe it or not, in a warped Dave Glissman sort of way, to business interruption insurance. So a casualty clause says, look, if the place burns down, I can get out of this lease or it gets abated. You know what they say. So the real question is a pandemic like this a casualty? And I think, that's a pretty hard argument to make. There are people making it. There's that one case, I read about it a while back. I want to say it's in California, San Francisco maybe, but I might be wrong. And the guy, the litigator on it is like a god. The guy is just a god, because he came up with this idea that because the COVID virus is sitting on the walls and the floors of the building, it's actually damaging the physical character of the building, and that's a casualty. Well, I don't know. Maybe it'll work. Who knows? They're going to litigate it all the way to the United States Supreme Court for the next 20 years. But casualty is one thing that people are looking at. And sometimes casualty clauses are drafted really broadly. So people are looking at casualty clauses now, and they're also thinking about casualty clauses for the future. Condemnation. Condemnation is like the stupidest clause in a lease, right? Nobody talks about condemnation. Well, a lot of them in the fancier leases have a provision in them that talks about governmental interference with the ability to use the premises. And that may constitute a, quote, condemnation within the meaning of that. So landlords are desperately looking at their clauses and trying to find out how easy they were with all this stuff. So anyway, there's a few more clauses that I think people are interested in. And the last one if we're going to get to force majeure, which I think you probably want to, is quiet enjoyment. Quiet enjoyment is a clause in the lease that says, look, as long as you pay your rent and do what you're supposed to do, don't worry, you will live a happy and fruitful life. And so they're drafted in two different versions, one by the landlord and one by the tenant. The one that I just said is by the tenant. And a tenant that has a quiet enjoyment clause like that says, guess what, folks? I'm shut down. My life is not happy. I'm miserable. I'm not paying rent. They're looking at the quiet enjoyment clause. The other ones that are drafted by landlord's attorneys say through hindrance or molestation caused by the landlord. And on those, they're kind of, out of luck. So then, Art, may I jump into force majeure?
Yeah, no, go.
I think that's really interesting.
I kind of laid it all out for you, and
I think you did.
Go.
It's funny how that is, huh? Okay, so force majeure, it is clearly the hot item, I think, for all of your clients and for you guys. So here's the thing on force majeure. What you're trying to get at is this concept that something really bad has happened. I can't use my space. I don't want to pay the rent. I'm not going to do anything else. Force majeure. That's a contractual agreement between a landlord and a tenant, and it is governed by the words in the force majeure clause. And there's kind of, three things in a force majeure clause that you have to look at. The first one is, what are the causes that give rise to the rights? Well, it's not a fire, it's etc. But a lot of force majeure clauses say acts of government, the inability to get supplies. There is good stuff in a lot of force majeure clauses for tenants and bad stuff for landlords, but it's kind of just in there. So you have to first look at the language, and this is no free lunch. You have to get the stupid lease out, look at the language, see what it says. The second thing is, are there any exceptions to it? Well, guess what? The bad news for the tenants, the good news for the landlords is that most force majeure clauses have a sentence that reads, notwithstanding, no provision herein shall permit tenant to cease paying rent. Rent is almost always carved out of a force majeure provision. So let's say you get through those two elements. You found a cause, governmental act. There's no exception for rent or anything else relevant. So now the question is, what does it do for you? Well, then you have to read it, because it goes on to say, and therefore, if you have it, here's what happens. So, and then again, it's contract. You don't have to pay rent. You can terminate. Maybe you don't have to pay rent for 30 days or 60 days, and then you have to start paying rent. So that's a heavily negotiated clause if it's a heavily negotiated lease. But force majeure, you guys, is something that people need to be looking at. But let's just say force majeure blows up in your face. There's nothing for it. So there's a second approach to this, which is called the common law. So if you can't find it in a contract, there are these three doctrines. They're impossibility, impracticability, and frustration of purpose. All you have to know is there's these common law theories that you can work with, and they're going to be done by a litigator, so we're not going to spend much time about it. But the bottom line is, if you can't find it out through quiet enjoyment, force majeure, or beating up, this is for the tenants right now, beating up the landlord with one of the other provisions that they're messed up on, you can look at these three theories of common law that basically say, look, if it's really a full train wreck, there may be a common law remedy for you here. There's a lot of bad cases on it in Connecticut for tenants, a lot of good cases on it for landlords, but we do have that kind of case law that I think is sitting out there, and the guys representing the tenants and pounding on their chests are all quoting it.
Okay. So we're going to move off of leases shortly, but there was a question about business interruption.
Oh, thank you.
And that insurers are denying claims, and just curious what your experience is with that.
So we've actually spent a fair amount of time, thanks Art, I forgot to mention that. We've actually spent a fair amount of time talking to clients about it. So here's the scoop with business interruption insurance. It might be available, it might. And a lot of guys are saying, just file the stupid claim and fight about it later. Business interruption insurance is generally based upon a casualty. Some of them are drafted more broadly to pick up other things. But there's kind of a link between most business interruption and casualty. So if the place burns down, the tenant gets business interruption, he can keep paying the rent or doing what he needs to do. The landlord has rent loss insurance, he can collect the rent loss insurance. But what most people are finding is that the nexus between a casualty type event and the trigger for business interruption insurance is not good. The second thing is that a few years ago, the insurance industry, because of SARS, started putting in virus exceptions in all their policies. So tons of rent loss and business interruption have virus exceptions in them. And it turns out all the clients that came to us pounding on their chests, ready to make claims, turned out they had virus exceptions in their policies. I think a lot of people do.
Ouch.
Yeah.
So let's move on to purchase and sale agreements. Beyond, I'm sure most people that have been negotiating purchase and sale agreements of late are, trying to work in, opportunities for extending diligence for obvious reasons. But are you seeing any changes with those documents? Any new clauses? Given the world we're living in now.
Well, it's funny that you should ask, Art. So it is kind of interesting. So I'm in the thick of these deals that have just come in, and they're with, clients who want to buy these properties. So we're seeing things like, 30 days due deal, 45 days due deal, and not a lot of changes in the documents related to COVID. And but I think there are issues. So contracts that we presently are in and we're doing due deal on and whatnot, people going for permits and approvals or whatever, almost all of them we're going back for extensions. And I think, truthfully, you're kind of nuts in this market to not bargain for extension rights now. If you're desperate, which some buyers really want the deal, they'll go with their 30 or 45 days and they'll just count on the seller being a reasonable person later on and extending. A lot of people do that, and it's not a foolish strategy, but it's not without risk right now, because here's what we are seeing. So we're seeing things like, as part of due deal, so we're under contract, you got to get a title report. The title companies are saying in some jurisdictions, no problem. In other jurisdictions, we can't get a title report. I have due deal ending on June 26th for a new apartment complex deal. We can't get in the town to do title work on it. We can't get in. So the other thing is, as part of most people's due diligence, a lot of them do what I call like a town hall sniff test. They go, somebody goes into town hall, you go through the files on the property, CO, violations, permits and approvals. You just kind of sniff around and make sure it's not a troublesome property. Well, you can't do that anymore. And so how do you deal with that? Well, you probably can get a zoning compliance letter from the zoning official. You probably can get a copy of the CO. Some towns have a nice guy or two. They might send you stuff, but most won't send you anything. So you just got to make a business decision. Do I care? And a lot of clients say, no, I don't care, Gliss. Why do you even worry about stuff like that? And then the next thing, and I think it is relevant to you when you're listing properties and to you when you're putting offers in on properties, is, how do you get to all the site due diligence, all of the leases, all the lease correspondence, all the financial information, all the vendor agreements, etc. Well, for most of you guys, because you're the top dogs, you put up these beautiful online data lockers and they have everything in them. Great. But there's still a lot of one-arm paper hangers out there that own 3-4 buildings and they're selling them. And they're not about to go through their garage and their office and pull everything and put it neatly into a data locker. So now we are, and we're just starting. I don't really know the answer, by the way, but we really are now just starting negotiations on, well, tough. You're going to have to package it up because our guys don't want to come and sit in your offices, and we want fresh, clean copies of everything. So we're starting that. And I think that when you go to put these deals together, probably data lockers are even more important now, than they were in the past. I think that one more thing, I think you have to say, in the current market of lending, which is not very impressive, I think, nobody wants to put a mortgage contingency in because it just, makes the big boys look weak. But if you're planning on borrowing and it's critical, it's hard to get money right now. I'd be thinking long and hard about waiving a mortgage contingency.
Okay. We could spend a whole session on lending and and the work that you're doing from a legal perspective. But we have a few minutes left, but any comments in terms of uh, work that you're doing with
Yep.
lenders on behalf of your clients, and what's going on right now?
Yep. So yeah, I've been watching the clock. We promise we're not going to extend this, you guys, too long. I had told Art I would like to talk for about 3 hours, and he said, no, I don't think so, Dave. So I think, what I'm hearing on the street and in the marketplace is nothing different than what you're hearing. It's really hard to lock up money. And so I reached out to some of my lender counsel buddies who represent lots of lenders and said, so what's going on? And it was interesting because it was kind of two things. The first one was that all the loan officers have been flat out on the PPP work, and they couldn't return phone calls. They don't want to talk to you. They don't want to underwrite deals. They're just out of control. They don't want to think about new deals. They can't. And then the comment to that was, and guess what, Glissman? It's about to happen again, because all those PPPs are about to end. The 8-week period is about to end in another couple weeks. And everybody's going to start filing forgiveness applications. So all these people that you want to go talk to, your lender buddies, are going to be out of control again, processing all of the forgiveness applications. That was number one. I was surprised that that was a factor. And then the second thing is the obvious one. It sounds like lenders are spooked, as everybody is, and they're just like everybody, about what's going to happen in the fall. And a lot of them are saying that they are just going to sit this out and kind of see what's happening. And an example of that, so I have one client is pretty well-heeled developer, and it's got got a lot of property, a lot of lender contacts. It's got a property that's got an appraisal of 30 million. It's looking to just put 10 million on it. It's going to all of his usual guys, and they're all saying, you know what, it's got great LTV, great cash flow. They're saying, we're just not interested in it right now. And this guy says, Dave, I'm not really worried. I know enough. I'll find somebody. I know this is a good deal. But it's hard to find money. And I think that for many of you, owner-occupied is just not going to be a problem. I think you're going to find that kind of financing out there. But I think when you go into investor, it's going to be much harder. And sort of my last kind of lending comment and a practice note for you is, I believe that if you can get a lender's attention, which will be a task in and of itself, if you can get a lender's attention, you're going to get in the door. They're not just going to look at your client and the appraised value of the building and the rent and the cash flow. I think they're going to be looking at the tenants. And what are these tenants going to be like 6 months from now? And I think that once you have kind of put this whole deal together, you've got the buyer and the seller together, you got your purchase and sale agreement, I think it's as important to the deal as putting the base deal together as it is for you to help your client, the buyer, borrower, come up with a story on these tenants that say, not only do I have a good rent roll in terms of the cash flow from this property and a great appraisal, but these tenants are the kind of tenants that are going to stick around. And I think they're going to withstand any bumps in the road that may come down the road. You may not be able to do that, but if you can, I think it's going to help, because I think lenders are going to be looking at that.
Hi, it's Bernadette. I just got a text from Art, had a power surge and got disconnected. He's trying to log back in, but I haven't seen him pop up yet. So just any other comments that you might want to wrap up with?
Well, sure. So I'll tell you what, everybody, it's 4:47. The deal with all of you is 45 minutes. So if you guys want to, shut off, feel free. There are a few chat questions. And so I'm just going to take a quick look at them. If there's any that I don't know the answer to, I'm going to ignore them. And just see, it looks like most of these things talk about things that I've already talked about. So interesting, somebody here is asking, who is it that's asking this? Tom. is asking the question, you know, are you dealing with the Starbucks of the world and stuff like that? Yeah, sort of. Starbucks sent a letter out to all their landlords saying, we're going to come talk to you. Be prepared. We're going to shake you down. And we're waiting for the second letter. We've gotten that on a few clients. We haven't gotten the shakedown call yet. But I talked about what retailers are starting to do. I think most of the retailers are going to be asking for serious shaves. I had one situation, I'm not going to say who the tenant is, but it was a fairly good sized tenant, and this was a very interesting strategy. One of the landlords, who as a single landlord might not do so well, got together a group of landlords that all had the same tenant in their centers around Connecticut. And they banded together and they negotiated as a group, which I thought was kind of an interesting strategy. I don't know how often you can do that, but I thought that was kind of an interesting approach to it. And the rest of these is our stuff that I think I've already talked about. I apologize, I'm just gonna look at one more here. So here's a good one. Tom, you're doing great questions, thank you. So when you have this problem with you can't get into town hall and you can't get into another attorney, into the seller's offices, can you put a gap stop on that through reps, warranties, and indemnifications? And the answer is yes. I think it's really hard in the kind of deals where a seller says, look, you can come look at everything, but I'm not doing anything for you. Those are the kind of guys that don't readily agree to long reps and big indemnities. But I think that's a perfectly appropriate solution. And then I think you're talking about, you know, the time caps and maybe a floor and what they're applicable to. But I think that's an excellent solution. Of course, if it's a single asset entity, selling its only asset and liquidating the day after the closing, you also have to be talking about an escrow. And that's it, you guys. So I want to thank you all for joining us, and I hope that was helpful. I love this stuff. It was very interesting. And Bernadette, I guess I'll let you shut us down. Thank you all very much for joining us.
Thank you very much, Dave. This is great. Bye, everybody.